Now, the Supreme Court has, in a unanimous decision, ruled that the Electoral Commission has the power to compile a new register. Private citizen Mark Benson and the opposition NDC filed the case in court asking that it stops the EC from compiling the register or allow the use of birth certificate and the existing voter's ID card by prospective voters as proofs of identification. The Commission, in its legal argument, said the existing voter register, which was compiled in 2012 and revised since by limited exercises, has been held by the Apex Court as not reasonably credible. Deputy Attorney General Godfrey Yeboah-Dame urged the courts not to impede the EC's quest to obey the law. We're joined by lawyer Samson Ladi for more on this perspective to this particular ruling. We also hear from Godfrey Yeboah-Dame as well. Samson, so let's break it down as far as what this ruling means. I've seen a lot of conversations going on, especially even on social media, where people are saying they've allowed the existing voter's ID card to be used as identification, etc. Help us. It looks like you are muted, Samson.
I did that earlier.
I know. Okay.
So Gipsy, there's no need belaboring any points. And the Supreme Court's decision today, simply put, is that the Electoral Commission should go ahead with its planned voter registration exercise pursuant to the CI that Parliament has endorsed. It should go ahead, and I think the other aspects that people are bringing unnecessary debates into the judgment is whether or not existing voter ID cards can be used as source document for the registration. The answer is in the negative, no. Now, as the discussion we had, back end, if you look at what the NDC asked for in the court, just look at two of the most important things they asked of the court and ask yourself whether those two important reliefs were granted or they were dismissed, denied, or refused.
Okay.
Once you answer that those reliefs were not granted, but they were dismissed, denied, or refused, therein is your answer and the summary of all this needless controversy. And the summary is that Electoral Commission is to go ahead with its registration exercise using the CI that has just been passed in Parliament.
Okay, Samson, just to interrupt you briefly, I will read the reliefs, the 4 and 5, if that helps, right? So the 4 says, a declaration that upon a true and proper interpretation of provisions of the Constitution, particularly Article 42 of the Constitution, all existing voter identification cards duly issued by the second defendant to registered voters are valid for purposes of identifying such persons in the exercise of the right to vote. So that's the number 4, the 4th relief sought by the NDC. The 5th is a declaration that upon a true and proper interpretation of the Constitution, specifically Article 42 and the second defendant's purported amendments of Regulation 1, Sub-Regulation 3, it goes on and on and on, through the Public Elections Registration Regulation 2020 to exclude existing voter identification cards as proof of identification to enable a person apply for registration as a voter is unconstitutional. So they want it to be declared unconstitutional, null and void, and of no effect whatsoever, just to help those who haven't seen it.
Right. So you see, the NDC was asked to choose certain reliefs, And one of the reliefs it withdrew was that the Electoral Commission does not have power to compile a voters register more than once, and that once it had compiled one some years ago, that's what has to be used. It withdrew that one. Another person sued. That person who sued brought this relief back. That one too has been denied. Now, the court granted something to the NDC, and I think that is the confusion. What it granted was the NDC's first alternative relief, and which relief is that a declaration that upon a true and proper interpretation of the provisions of the Constitution, specifically Article 51, read conjunctly with Article 42 of the Constitution, the power of the second defendant to compile and review voters' register must be exercised subject to respect for and the protection of the rights of to vote. And the court said yes, that's correct. That doesn't mean anything. That doesn't mean the existing voters register should be used. So if you skip that one and then you got to their relief 4, which I asked you to read and you did. In that relief 4, they were asking that if the EC is doing what it has to do, it must not do and exclude the existing voter identification cards from the documents required as proof of identification. That's what they said. And this one, the court denied it. The court said, we can't grant you that because it's not made out. And then the 8th relief was for the court to order the EC to include all existing voter identification cards duly issued by the EC as one of the documents serving as proof of identification for registration, for registration of a voter for the purposes of public elections. That one too, the court refused it.
Okay.
So bottom line, let's not waste anybody's time. Bottom line, the court says, Electoral Commission, you had planned to do a voters register process. Please go ahead and do the voter registration exercise. Use the CI, constitutional instrument, which Parliament just passed, to do it. What does that CI say? It says you must use your Ghana card, you must use a passport, or you must have a guarantor. Simply, this is what it is. So the EC is going to go ahead in the manner that it planned, using the CI that it got Parliament to pass. End of story.
I'll come to you. I want you to listen to the Deputy Attorney General, Godfrey Yeboah-Dame, who we've been speaking to. And there have been a lot of responses since the Supreme Court's ruling, including the General Secretary of the NDC, Johnson Asiedu-Nketia, who has also made some comments. Godfrey Yeboah-Dame has described those comments as misleading. He's also adding that the NDC has been badly bruised and must face the music and stop misleading the public. He asked that no relief of the party was granted by the Apex Court and wondering why, in his words, the NDC is jubilating. Let's listen to Mr. Yeboah-Dame, and then something I'd like to take your thoughts after you've heard him.
Because I think that the court is very good. It protects the rights of the Ghanaian to vote, in the sense that it shows that clearly it is intended to ensure that only Ghanaians who are qualified to vote, they register to vote.
In terms of the ratio of the court, it affirmed the independence of the EC once it's not acting contrary to law, and again gave orders as to compiling the register in accordance with CI 126. I'm sure you have seen what the NDC General Secretary has been saying. Are you surprised with the interpretation that has been put on the decision of the court, and what is the AG's position on the decision of the court?
totally amazed at the ridiculous interpretation that was based on the court ruling by the NDC, especially the NDC General Secretary. And clearly, it's only a person who perhaps did not have an understanding of what the court said today who made such a conclusion. It is quite clear. They have the ruling of the court before, and you have to just match it against the specific reliefs that were sought by the NDC. And you see that clearly in terms of the substantive reliefs, they were all dismissed. The substantive reliefs were relief 4, which was a declaration that upon a true and proper interpretation of the provisions of the Constitution, as well as Article 42 of the Constitution, all existing voter ID cards to be issued by the second defendant of the Electoral Commission to registered voters are valid. That's the NDC's claim. Now, what did the court say? The court stated this is the Constitution. The two reliefs did not add anything at all to the NDC case at all. They were a clear statement of what the Constitution has stated. Because if you seek a relief that a declaration of a true appointed to the Constitution, specifically Article 51, read conjointly with Article 42 of the Constitution, the power of the second defendant to compile and review the voters' register must be exercised subject to respect for the right to vote. What have you sought? Nothing at all. We are only stating what the Constitution impliedly and explicitly states. That indeed the right to vote must be respected. Yes, the court is granted. So what? It's empty, it's nothing. Then you go to the other relief that was granted. The declaration of the true and proper interpretation of the provisions of the Constitution, particularly Article 42, upon registration of and issuance of voter identification card to a person, that person has an accrued right to vote, which cannot be divested in an arbitrary or capricious manner. Again, that's what the Constitution implies and expects. And what did the court say? Relief 3, no, sorry. So the court stated that relief 3, the relief is granted subject to the voter registration card issued to an eligible voter under the prevailing constitutional instrument CI 126. So it's clearly that yes, we even agree with your contentions, which is, as I indicated, what the Constitution expects.
Some say, I beg your pardon, Godfrey Yeboadame, the Deputy Attorney General, will be hearing more of his clearer conversation in our next bulletin. But he's also been adding that the NDC shot itself in the foot by going to court in the first place with the disenfranchisement claims. He insists it was not backed by any research, evidence, documents or data. And he says they came to the court empty-handed.
To the court. Do you think what the court has concluded that indeed looking back at the brief that they had intended to submit, the court would have determined differently if it had allowed that amicus to go in?
Oh, definitely not. I mean, I took a very serious look at the amicus brief because indeed I realized that they are sought to attack the submission that I had found. And so indeed, when the lawyer got up in court to say that he had not read the submissions, the first point I made was to point out to the court that he was not being candid to the court. So first of all, you find a person who is a party to the case coming into by way of a third-party intervention who is not even candid to the court. I think that that's very deplorable. So and then you will see that in his submissions, virtually what was he bringing? Nothing at all, but just the same as the submissions that are filed by the NDC and Itachibansi. So really all he was seeking to do is to make multiplicity of arguments in respect to the same issue. And that is nothing new. Even if you look at the value of the amicus brief, I made the point that there are only two cases that were cited in the amicus brief. It's a common law tradition, it's a tradition that thrives on the passage of statutes and decisions made by Supreme Court of jurisdiction. Indeed, there's specific subject matter in this. There are many cases that could be referred to. That would be
by the Supreme Court.
No, the Supreme Court under Article 129 of the Constitution has the power to exercise all powers vested in any court at all. We call it the residual power of the Supreme Court. They can exercise all powers that are lawfully vested in any court or tribunal in the country. So the Supreme Court, in exercise of the powers conferred on it by the Constitution, Article 129, has made this consequential on this. And all courts are supposed to comply. I think the essence is quite clear that there ought to be order in the administration of justice. There cannot be a situation where the Supreme Court has taken its time to adjudicate on this matter, made orders which are binding on the NDC and all citizens, and then another citizen will be prosecuting another matter in the lower court. So for the sake of ensuring order and an efficient administration of justice, the Supreme Court has exercised its powers in Article 129 and made its orders, and all courts will be required to comply.
Well, one thing that came up in the course of this proceeding has to do with the amicus application. You had argued that
So that's Godfrey Diabwa Dami there speaking to Joseph Akable. Like I said, we'll bring you a longer version of that information or that interview, I beg your pardon, in which it's a bit clearer. So sincere apologies for that sound there. But I'm being joined by NDC's, pro-NDC think tank, I should say, ASEPA. Mensa Thompson is head of that organization. He and some other civil society groups had wanted to join the NDC's case but were disallowed. Let's get him right now and his thoughts on the decision taken by the Supreme Court. Mr. Thompson, I see you moving your camera around a bit. Can you hear me?
Is it okay?
Yes, it is okay. And if we can get some stability in the sound in your background, that will help us a lot.
Sure, I'm working on that.
All right. So first of all, I want to take your initial thoughts on this decision. You've been working very hard to get it the other way. It turned the other way. That's not in your favor.
Well, I think the ruling of the court as it stands is a bit confusing, and I would ask the applicant in this particular matter to file another process at the Supreme Court for further interpretation of the ruling, because as I speak, it's a bit confusing if you read the judgment, and it is easy for both parties to claim victory, as we are seeing right now. And depending on how you read the ruling and how you combine it with the constitutional provision and how you juxtapose it with the ruling of the court in the Abu Ramadan case, which the court had affirmed in this instance, also makes it a bit more confusing, you know. So what else can we do than to file a process at the Supreme Court for the judges who the law is in their bosom to give a clearer interpretation of their ruling to the minds of the ordinary Ghanaian? Because as we speak, for me, it's a no victory for anyone. So
hang on. I just spoken to Samson Ladia, who gives us some explanation. And from what he says, if you look at the reliefs that the NDC, for example, sought, the 4, 5, and I think Samson added 8. If you look at the reliefs and the fact that those reliefs were dismissed, the reliefs, I've read it already. If they were dismissed, then it's obviously what you wanted or what the NDC wanted has been dismissed. And so it didn't go in your favor. Are you contesting that?
No. The Supreme Court reiterated in the judgment that, one, they have granted the relief of the use of the old voters' ID card, of the voters' ID card, which has been given under CI 126. As we speak, there is no voters register that has been given, under CI 126.
Okay, I don't have that part of the judgment, but what I do have, yes, which I read
that is under the relief 3. Look at the relief 3 in the first consolidated case between the NDC and then the Attorney General and the Electoral Commission. You will see that relief 3 is said relief 3 granted, and it talks about the use of the existing voters ID card that has been given under CI 126.
Okay, let me just try and read the relief 3. I just want us to be able to carry our viewers along so that there is no confusion here. Relief 3 is the NDC is asking for a declaration that all existing voter ID cards are valid for identifying persons in the exercise of the right to vote. The court's decision on that is denied.
The court decision
On that is relief 3. Okay, right. Hang on. Sorry, I went to relief 4. Okay, so relief 3, the court's decision is yes, but subject to a voter ID issued under the CI 126. Wait, aren't they referring to a CI, a new voter ID that the EC will now have to register people for?
Yeah, so as we speak, no voter's ID card has been given under CI 126. But in the same ruling, the Supreme Court is also affirming its ruling in the Abu Ramadan case, Abu Ramadan 2. And if you know the decision of the court in Abu Ramadan 2, what the court was saying, the court gave 4 main documents as a means or legitimate means of identification for registration. And that were the voter's ID card, the passport, the driver's license, and the birth certificate. And so if you take this ruling vis-a-vis the court's decision in Abu Ramadan, which it has emphasized in this particular ruling and upheld in this same ruling, then it creates a bit of confusion there. And that's why I'm saying that the applicant should go back to the court for the court to give a clearer interpretation of its own judgment. Otherwise, the confusion lingers on, and I don't see why anybody will be claiming victory.
Okay, so if you talk about confusion, and I just want to bring your attention once again to the fact that it's not just relief 4. So you have relief 4 denied, relief 5 denied, move to relief 8 denied, and it's all talking about how the NDC wanted the old voters register or the existing voters register to be part of forms of identification. 3 different reliefs denied. Directing to the same thing. Does that not give you the indication that there is absolutely no confusion in the mind of the Supreme Court judges?
There is so much confusion in this particular ruling, and if you read the ruling in its entirety and the declarations that the court has made, there's a lot of confusion out there. There's a lot of confusion in this particular ruling, and I don't think that there's anybody better placed to give or interpret this ruling other than the Supreme Court itself. Okay.
So, let me just draw your attention also to something that you wrote when the Supreme Court finally ruled. You say that the Supreme Court, and this is a statement you put out there, the Supreme Court has just ruled for the inclusion of the old voters ID card as a requirement in the compilation of a new register. Now it is clear why the judges threw our amicus away yesterday. The court didn't want we, the CSO, to take the credit for forcing the judges to do the right thing. When you said this, was there confusion in your mind, or were you deliberately creating misinformation?
Read the ruling out there. What I picked up was that the court has granted the use of the old voters ID card, and I still stand by that decision. Okay. And that is why I'm saying that subsequently I have heard a number of legal experts also making different interpretations of this particular ruling, and that has created a number of confusions out there. And so if you look at the conversation out there, different legal opinions out there, different legal, understanding of the ruling of the court.
And so your decision is to go back to the court. How soon are you doing that?
I'm not an applicant in the case. We are not an applicant in this particular case. In fact, our amicus was rejected. If our amicus were to be having accepted yesterday, of course, would have given us some locus to go back to the court. Okay. But it is the onus lies on the applicants now to go back to the court and seek further interpretation of this particular ruling.
Mr. Thompson, thank you very much for your time this afternoon. And I wish you all the best in your endeavors. Mr. Thompson is head of ASEPA, is a think tank. They tried to join in this particular case, but they weren't allowed to. He says there's a lot of confusion.